Welcome to the Tinnelly Talks podcast, where we dive into the common legal issues facing today's community associations. Whether you're a manager, board member, or homeowner, you're sure to pick up on some nuggets of advice to help you build a successful community in this ever-evolving and changing world.
Hello, and welcome to Tinnelly Talks. I'm Ramona Acosta.
And I'm Steve Tinnelly.
And today we're discussing HOA elections with Cathy Tinnelly and Cheryl Wilson of Accurate Voting Services.
So Accurate Voting Services is an independent inspector of election company that meets the unique election needs of California homeowners associations. And as Ramona said, Cathy's last name is Tinnelly and my last name is Tinnelly. So full disclosure, I've got my mommy sitting here next to us in the recording room, and I'm really pumped for you to be here today. Thanks for joining us, Cathy and Cheryl.
You're welcome.
Thank you for inviting us.
Thanks for having us.
So independent inspector of elections, the topic of HOA elections is always something that's kind of at the forefront, especially with SB 323 that took effect at the first of 2020 that kind of changed the election process. So I'd love for you ladies just to kind of give us a background on what it is that you do for associations and kind of the unique need that your company fills.
Well, we are a full-service inspector of election company, and so we provide our proposals to the managers, and when our contract has been approved, then we jump in concert with management, prepare as much as we can to get the election in the mail. We discuss a lot of times the time frame to assist the manager in that regard, and then we, at the appropriate time, no less than 30 days prior to the election date, mail the election materials to the members. The ballot return envelopes come to us. We keep all of the ballot return envelopes in our care and custody. We update the managers how many ballots we have received to achieve quorum. We attend the meeting upon quorum achievement. We tabulate the votes. We provide our inspector report, and then per California law, we retain the complete election materials for 12 months, thereafter return to management. So that's kind of a nutshell of our services.
So the whole thing, full service.
100%, no
Start to
partial
finish.
service for us, yes. No
No
bits and pieces, just full service. We believe that is the spirit of the law. Others mail it, we show up and count it. No, we do everything.
You do everything. You handle it.
I got to tell you, as a former community manager, I love that. Just to be able to hand you the voter registration list or the homeowner list and just, here you go, please take it.
It does seem to be appreciated by the managers, for sure. So they have a big job to do because they need to send out the call for candidates. When the deadline comes, receive the candidate names, the resumes of the candidates, send out the 60-day before the election date notice to the members, and then provide that to us. So they still have a lot of important work to do, but the nitty-gritty of the election itself, they seem to be very, very pleased. Especially for managers who've never been able to have an outsourced company.
Yes.
They love it.
Got it. So this is kind of a new thing for those managers because before SB 323, I mean, the law has for a long time required an inspector of election to oversee the election, but a lot of management firms before SB 323 would actually perform that work on behalf of their clients. And one of the unique reasons behind SB 323 was the legislature said, no, we don't want anybody who's under contract with the association, which could be management, it could be our law firm. Mm-hmm. They don't want us serving as the inspector. They want the association to contract with a third-party company, which, from what I understand, caused a lot of management firms to shift and say, wait a second, now we've got to really actually start pitching this to an Accurate Voting Services type of company to come in and handle it. So it's probably been a first impression for a lot of managers, and I'm sure they're relieved by not having to do as much of the laboring ore as they did previously.
They often compliment us on how easy and they're able to get through their election, how much they enjoy us representing.
We really are part of their team.
Yeah.
And they do appreciate that. Because the law started July 1, 2006, but it wasn't really adhered to for the most part.
Got it.
And here we are 15 years later, and it's a real for sure law. So, as you said, the compliance with many management companies is new, and it trickles down to the managers who never had the opportunity to outsource. So we do find that we're pretty appreciated, and
Often the managers will say, thank you so much for helping us through this, navigating the waters of the new election law, and so we're really happy to do that. And we're appreciated, and that makes us feel good too.
Awesome. Well, that's cool. And I know, under the new state of the law and the prior state of the law, still allows this unique carve-out that allows an association to have the third-party inspector be a homeowner, volunteer homeowner. The homeowner can't be related to any candidate for the board if it's a board election, or or actually be on the board themselves. Obviously, you don't want to be a candidate.
Correct.
Yeah, I'm going to count the ballots for myself here. That makes a lot of sense. Do you find that communities are doing that, or they're successful with that? Have you any insight on what? Because sometimes we get asked by our clients to say, "Hey, can we have a homeowner do it?" What's your experience been?
Well, we're out. So our belief in the spirit of the law truly is that a true job duty of an inspector of election is to do everything, as I said, mail it, collect it, receive it, keep everything in our care and custody, tabulate all the way through, full service. So for you to bits and pieces and have someone who, with all good intentions, say, I think I could show up and count. I've never seen anything before. I've never done this before, but what do? I don't know how accurate it's going to be, but I want to volunteer. No, then we're not involved in that, so not a good idea.
Well, I've always been surprised. How do you deal with the custody issue? So when the inspector's receiving these ballots and has to retain custody it's a year, the time frame, right?
12 months, correct.
So, we have Bob the homeowner, and Bob's a well-intentioned guy, and he wants to help the community out. Sure, I'll volunteer time. Where's Bob keeping custody of these?
Bob's not.
He's not. Where are they getting stored then?
Bob's giving it to the management company.
Got it.
If there's any kind of challenge, then Bob didn't have it in his care and custody.
Got it.
I'm not sure how that goes sideways. That'd be a tough one.
And there's so many other issues with, the homeowner. You and I had this conversation earlier. The homeowner is well-intentioned, but things come up and the homeowner doesn't show up at the meeting to do the counting. There are decisions that the inspector has to make when a ballot is not completed correctly or the outside of the envelope is not completed correctly. And do you want a volunteer homeowner making those types of decisions? So there's so many issues as to, a homeowner can do it, and that might be more cost effective for the association in the beginning, but could turn into other problems later on down the road.
Definitely. It's so nuanced. It's not just showing up and counting. Mm-hmm. We have mailed, collected, and we date and timestamp every single envelope every single day as we receive it. Everything's every envelope is 100% looking against the membership list to make sure that the person who signed it, their name matches the ownership list. There's just so much involved. It's not just a show up and count.
Mm-hmm. Yeah.
Counting is the simplest part of
the counting is so nothing part of it, yeah, because quorum is achieved by the number of envelopes, right, correctly prepared. And then you open up those envelopes and all kinds of things you're going to find. If you're not really a professional and very well versed and you have a lot of experience, I don't know what a good-hearted volunteer would even know how to accurately take care of those things.
Yeah.
So these are corporations, and we just take it all very seriously to do the very best, most professional and accurate job, and it's served us well for over 15 years now.
there you go. One thing I think that a lot of community managers and boards don't understand is with SB 323, the bar has been lowered and made it a lot easier for homeowners to actually challenge the results of an election based upon a defect in the way in which the election was conducted, which is why a lot of times we tell our clients, listen, even if you could do this to shave a buck here or there or try to make the process, you're leaving a skeleton in the closet, because if this thing's not complied with, the legislature in adopting this new bill is pretty specific that, we're corporations, but more and more they look at us as quasi-governments, right? We're serving a public service here, and this thing needs to be done with every T crossed and every I dotted, and if it's not done that way, homeowners have a pretty easy recourse to file an action, not even in superior court, but in small claims court, and to recover actually fees and penalties associated with it. So there's a risk inherent in doing these things, which is why I can understand the need for your services and to be able to conduct the whole process. Switching gears a little bit to the new election law, I know managers, we built an election timeline on our website to kind of help managers guide them through this process, because now there's an additional month, right, where we have to post notice of the nominating procedure and then obviously post notice of the candidates. And a lot of times you as Accurate Voting Services are relying on management to make sure that these notices, right, get posted. What is the biggest issue that you see, or the most common issue that you see in working with your clients that their managers might not understand, or something that they overlook?
They just lose track of the calendar, and all of a sudden they realize they missed all those very important timely steps, and they just have to push their election date out to catch up to all the steps they have to take.
So if that's the remedy, then say, okay, well, that's kind of, it's always we're service providers to these associations, right? We all work together to serve the association, and nobody wants to mess up a process, because then, okay, our service providers are not getting the job done, and then finger pointing starts. So what's the remedy then? If there's a defect in something like that, we just push the election back a little bit?
Yes.
That's all we can offer for a solution, because all those they're so time sensitive, every step. And you can't back up in time. So if you missed your call for candidates, if you missed your whatever step you miss, the only thing you really can do is get it back on track, go further out in the future for a date, and back up.
Well, and I think, just to take a step back, we're still seeing SB 323 went into effect January 1st
of 2020.
Of 2020. We are still receiving requests from associations for new election rules to comply with a bill that went into effect last year.
Oh, man.
So, and in the first quarter of 2020, we said, okay, well, do the best that you can do, right? Because election rules had to be changed and updated no less than 90 days prior to the mailing of the nomination procedures, right? Well, nobody could comply with that because of the way the calendar fell. So it was, do the best that you can, push your election out, and then you have all of 2020 so that you can comply in 2021. And I agree with you. I think that there was a pandemic, and then there were other issues that came into play, and other things that became more of a priority, and elections fell further and further down the priority list. And now we're in 2021, and we still have election rules that need to be adopted 90 days before the nomination forms.
Yes. We have a few managers who simply just took the year off.
Yeah.
They just took 2020 off, and they just simply didn't have elections. So it's a real catch up now. Yeah, that's happening.
So in a situation where you need to push the election, sometimes we'll get calls from, oh my gosh, this is the world is ending. We've got to push the election. It's going to be such a big deal. Everybody's going to be upset. What's your experience? Does the membership typically react negatively to that? Is it that big of a deal, or do you just kind of explain that we have to push it back because we have to comply with the law? What do you see on the ground when you're in the middle of that?
Well, we don't really. The members have not. We haven't seen really.
The members wouldn't know what they don't know
from the members, and I think what we're seeing is that everybody wanted to at least get their election done in the year. For the year 2020, by the end of the year 2020. So elections that were scheduled to take place, say, in May, might have happened in November. And so we had a big crunch to get everything done by year end. And what we're noticing now is that even though they had an election in November, they are now scheduling their 2021 election for the normal month that they would normally have it. So they'll have November, and then they'll have, okay, now we're going to now schedule our election for May, even though it's only been a few months. So they're trying to
get back on their anniversary election month. They
and
are.
So far, and you've seen them; they've had success in that regard.
Oh yes.
Okay.
But back to your question, what do the members think? I don't think the members would know what they don't know. They didn't have a notice. They didn't get a call, so they're not looking for that particular date. So when the manager calls us, the manager realizes that they have lost track of the calendar.
Got it.
And if they call us enough time, we can help them. Maybe they'll only have to push it out maybe a week or two. They can keep the election month. We'll push out maybe a week or two, and then they can still have the steps. So we're calendaring all day long with management.
Got it. All right, so SB 323, another big component of it, dealt with qualifications for candidates. This way, I'm a homeowner, I want to run for the board. And the thought process was that associations, through their election rules, were adopting these qualifications that allowed board members to control who could actually be a qualified candidate by doing, some bad deeds. For example, we had one client that we were working with where we found out, I said, well, this is kind of the test case of what the legislature had in mind and didn't want to have happen. There was somebody that was going to be running for the board that the current board members didn't want to get on the board. So, of course, prior to the election, this individual homeowner who was a candidate, they found some sort of ticky-tack violation. Oh, they need paint on their fence or something along those lines. Then deemed them in violation of the governing documents, and therefore a member not in good standing, and therefore somebody who's not eligible to run. So what the legislature did is they said, no, we don't want to allow that. We're only going to allow associations to disqualify candidates for certain things. They have to be a member, right? Even if they're not current in the payment of assessments, there's carve out for that. So the legislature doesn't want boards to be able to do these types of things to disqualify people. I'm curious to know, what role does an inspector of election play when someone says, hey, wait a second, this person who's submitted their nomination form and should be a candidate, they're not qualified based on the association's election rules? Do you get involved in that at all, or is the association kind of feel that?
It does happen after the fact oftentimes. We did an election the other day that after the fact and after the tabulation, after the election results are reported, oh my goodness, we management probably didn't do the best job because one of the candidates hasn't been an owner for 1 year. So now we have to go to legal to figure out how we're going to undo that.
Got it.
But we're not part of the call for candidates, and we're not part of the vetting process of candidates. So we become involved after the 60-day notice has been posted. And now we know the date, time, place, we know the candidates' names and so on, then we start beginning to prepare the election materials.
Got it. And the voter roster, right, the list of the owners who are eligible to vote, that's something that's also provided to you by management as well? Okay, you don't administer any of that.
Correct. Yeah, the database comes from management.
Well, Steve, I mean, a question to you is, as an attorney, how involved should volunteer board members and managers be in the disqualification of candidates? You know, you must be a member. You know, you may or may not have the requirement to be a member for at least a year. Management companies, when we're talking about members, they have their roster. That roster may or may not correspond with the actual title to the property. And management companies aren't pulling title to confirm membership. So who should be making those decisions? Who should be vetting those candidates?
Today's episode is brought to you by Altera Assessment Recovery. Altera provides comprehensive attorney-supervised assessment collection services to community associations throughout California. Trust us with your collection needs. We'll get the job done right, and as quickly and efficiently as possible. Altera Assessment Recovery. We're the collection team you've been looking for.
Well, in terms of the member, yeah. So both, just for those of you that are listening, both Cheryl and Cathy are saying, not us. They're running for the door.
We would have no ability to do
that. To some respect, as legal counsel, we don't necessarily want to do that. But I mean, we're kind of the person that has to. In terms of us pulling a roster and making sure that everybody's on title and that that's something that's up to the association's custodian of records, right? That's management's job to do.
Right. Mm-hmm.
But my encouragement to a community manager, especially when you have somebody who's running for the board and there's it's a heated election. Oh, by the way, this person's actually not qualified to run, right? Under the new law, you actually have to give the person an opportunity to participate in IDR. There's before you just disqualify them. So if you're in a situation where, okay, we've got, Samantha who's running here, but Samantha's not qualified to run and Samantha's not going to be happy about this news, that would be a good situation to just run that up the flagpole a little bit to legal counsel and let us just kind of bless it. Because if the association gets named in an election suit, we're going to be the ones involved dealing with it. So, yeah, it's always good to make sure that everything is right before you pull the trigger on that type of stuff. Do you ever see issues with people that when ballots are coming in and someone says I was improperly disqualified, they show up at a meeting or anything along those lines? Any fireworks like that? Nothing really.
We haven't had that.
And we would, and even if that complaint came to us, we would have to refer them back to management because we just don't have the database. Mm-hmm. We don't know when you purchased your home. We don't have that kind of information, so we don't really have those kinds of questions asked of us.
Got it. Well, another interesting issue, this pops up every now and again, is obviously, as much as we would like to think that homeowners and association, once they get that ballot, they're so excited to complete the ballot. They're going to return the ballot on time because the association's going to make quorum. We're going to be able to conduct our election. Yeah, right. That's really not the scenario we deal with, right? We deal with a lot of membership apathy, and sometimes it's very difficult for an association to achieve quorum, right? And then there's usually a process in their documents that allows the association to adjourn the meeting. So when you have, let's say, a meeting that's scheduled for this date and you're not going to reach quorum and then you want to adjourn it to a later date so that you have a lower quorum requirement, how does that adjournment happen? Is that something that you facilitate? Does the board facilitate that? How does that typically work when you see that one association needs to adjourn a meeting to a later date?
Well, in today's world, because we're not all together in the same room and it's all been Zoom, mm-hmm. we're very clear to tell you that you're so far from quorum for the original election date. Perhaps you all would decide. When mm-hmm. I say you all, management would probably go to the board because that's the easiest contact, and they would decide on an adjourned date. Mm-hmm. And if they have adjourned quorum, we do it maybe next week. Mm-hmm. And then we go there, but we're not really instrumental in setting that date. We can offer, mm-hmm. but we're constantly updating how close you are to your original quorum, how close you are to your adjourned quorum, and then we just start calendaring it out.
Yeah, I mean, it was actually a client, it was 2 years ago where there was actually a lawsuit, and this stemmed from it, was that the meeting was not properly adjourned, because I don't think that a lot of managers and board members understand that a motion has to be made at that original schedule to adjourn the meeting, and notice has to be provided. Like, there is a formal procedure to do that.
Well, Steve, can you kind of go over that a little bit? Just because I've been that manager who's been in the position where I am by myself in the clubhouse parking lot. None of my board members have shown up for my annual meeting. None of my homeowners have shown up for my annual meeting. They're doing it all mail by ballot. Mm-hmm. I'm the only one there because somebody has to be there to count the ballots. And so I don't have quorum, and there's nobody there to make a motion. And so I'm speaking to the parking lot. Okay, the meeting is going to be adjourned for 5 days from now because I have enough for my reduced quorum. That's technically not correct, but I don't know what else to do in that particular situation because there's nobody there.
In that situation, you've got to have at least, that's when you have to tap one of your board members and say you at least have to be there. Someone needs to, be able to make a motion. Two of you are there. We have to adjourn this meeting and we have to do this thing properly because in the event this thing is challenged, and we saw it with this client, there was a significant lawsuit that emanated from it, and it dealt with the issue, and the judge ruled, the adjournment wasn't proper because a motion wasn't made at the meeting and notice wasn't properly provided. All management did was post a sticky taped a little notice on the door saying, hey, our meeting's going to be next week. So anybody who's coming, we're going to push it out to next week because now it's, quote, adjourned. But that wasn't the formal process. And who knows? I mean, that would come back to bite the association. But in this case, it was a recall election. So,
oh, wow.
Yeah, the stakes were...
That's even more special.
I know.
That's why I think that this conversation is important because, again, having done so many elections, it is not uncommon to only have one person show up. You're lucky to get the board to show up, especially if it's an election that you've had repeatedly because you haven't been able to get quorum. Mm-hmm. At some point, everyone just kind of gives up, and management's odd man out trying to have this election.
Yeah.
So I think it's important for both managers and board members to know that it's a membership meeting, but we still need you to be there. We need
you to be there because we're not at quorum, and we're going to need to adjourn it. In order for us to adjourn it, you actually have to make a motion, and that motion has to pass by the people who are present, right, whether it's digitally or in person,
because it was a duly noticed meeting. Mm-hmm. You can't get around that. So yes, it has to be formalized in some regard to be compliant. But you think that it's so irresistible. We think our election materials are so irresistible and they look so good and they're so inviting, but achieving quorum the first night is tough. It's still a challenge.
Do you ever work with associations that don't have quorum requirements, that they've been removed altogether?
A few.
Mm-hmm.
How does that work?
One ballot is quorum, and we count it that night. We know it's going to happen that night, no matter how many ballots we have.
Yeah, and for those communities, we've always kind of cautioned our clients against that because let's say you're a 100-unit community without quorum, you could have
ballot cast
one ballot cast that kind of rules the day. I mean that's what that quorum requirement is there for. It's to make sure that you have at least enough sampling of your membership, right, to understand what way the membership is leaning. So we've always been hesitant to tell, hey, can we just remove quorum altogether and make it? Well, do you really want that? Do you really want the potential for one or two ballots to decide?
I don't think that originally it was prepared that way when they built the development, but they have been amended.
Yeah.
I don't think door, I don't think that's how it was begun.
No, actually, I don't think that's allowed in the model documents, but we can.
But they have been amended, a handful of them, to have no quorum requirement. Mm-hmm. So we see it a little bit, but it's not from the original, it's from an amendment.
And some amendments
it's pretty crazy.
From 50% or the majority to 25%.
That's pretty typical, 50 to 25.
50 to 25. I've seen, for bigger communities, 25, and it'll step down to 15 or 10.
Correct.
But taking it down to 0 to me just kind of seems...
We don't see it often, but yes, there's a little bit out there. What's really hard is when the quorum does not reduce. Good luck with that. It's going to stay at 50%, and it's never going to reduce. Those are tough.
So you don't reach quorum, and then what? You try again next year, and then you reestablish.
Maybe 3 attempts, whatever you think is fair. Mm-hmm. Maybe 3 attempts is pretty typical. And
some
then you call it a day.
Just go
and they won't give up, and they'll just go. They'll go every single month for a year until it's time for next election to roll around. They just can't give up. Mm-hmm. So.
Got it. So yeah, we need to think of ways to encourage members to participate a little bit more, try to make the job a little bit easier.
Well, it's funny because you used to do the ice cream socials or the pizza parties, and at least for 2020 and part of 2021, you can't do that. You can't have the ice cream party at the
free
pool
coffee,
area,
free. Oh,
right?
yeah. There's been a lot of refreshments because it's their annual get together.
Yeah,
and those never have a problem with quorum.
Right,
never.
But I have to say, for this year with the pandemic, people have been home. And they've been able to focus on getting that ballot in.
It's been a little bit better. We thought it was even going to be better, but
more
yes,
often in some associations that we didn't achieve first time around this year with the pandemic. It's
so that
it's a little
they're at home and get a little something to do.
Yeah, they have something to do.
That's true.
Go to the mailbox.
That's true.
Both ballots and
drive over, hand deliver it.
Totally.
Gives them something to do.
I can't go outside, but I can go to my mailbox, right, and get that ballot. I got something to do today other than Netflix.
That's exactly right.
I get it.
I had an interesting question come up last week regarding equal access. And a manager asked me if a candidate could post a flyer in the common area as part of their campaigning. And I don't see anything that says that they can't do that. I said, but just keep in mind that there's an equal access, right? And so even though it's equal access to common area meeting space, I said, just keep in mind that anything that's good for one candidate is good for all the candidates. But I think we should probably talk about equal access, because it's not just equal access to meeting space, but it's equal access to media as well. Social media pages, newsletters, websites, right?
Yeah, absolutely. So, again, this is kind of another example of the legislature's treatment of us as quasi-government, right? This is a First Amendment thing. And these are rights that we need to vindicate for the homeowners. A lot of times where we see clients trip up on the equal access issues when the board is the one that kind of opens the door, because let's say it's a special assessment or a loan or some type of special election, right? Yep. And the board says, okay, what we need to do is we need to on the association's newsletter, and we'll post it everywhere, and the board will, under what the law defines it as, advocate a point of view. Right? And they're advocating, this is why you need to support the loan, this is why you need to support the special assessment for the repipe project. And they put that out, or they mail it out, or they put it on a newsletter. And by doing that, anybody in the community, not just a group of homeowners, or if it's a board election, the candidates, anybody in the community now is given, under the law, that same access. So, oh, by the way, the newsletter now needs to run the piece prepared by Judy, who's against this thing, that has all this venomous language about what the board's doing. And the board doesn't really realize that, well, they're going to run this through the newsletter. They can't run this through that's association. Well, you gave access to somebody advocating a point of view. No, it wasn't somebody. It was the board. Yeah, the board is somebody. There's case law on that. So do you see that issue pop up from time to time?
We're very involved in that.
Like what you hear so far? Make sure to subscribe to the Tinnelly Talks podcast at tinnellylaw.com and never miss an episode. This podcast is made possible by listeners like you. Thank you for your support. Now let's get back to the show.
There was an association that was very, very adamant about a particular, I think they wanted one of their pools to be turned into a garden, whatever the case was. And the board was so supportive of this particular special vote. And they did. They opened up the clubhouse. They had town hall meetings. They were on and on and on. And then the other side wanted to have their part. And they were denied. And that did go to court. All the way.
All the way to court?
And the board did lose. Because they did not allow equal access to the other side. 100%. That was years ago.
Yeah.
Years ago. So that's definitely a problem.
Well, now we have the benefit of learning from it. I mean, one of the things we always tell our clients, hey, there's a defect in the election process, or someone's challenging that they didn't get equal access. We always tell our clients, and I don't know if you see this because you work with communities, all throughout the state, not just those that we work with, right? But so I'm curious to know how other communities do it. We always take the position that there's something wrong, just redo the election. Or push it back. Do whatever you need to do to comply with this to give this person equal access. Because why are you going to allow somebody who's already shown that they want to be a thorn in your side to give them a legal avenue to do that and to kind of rub the associations and the board's nose and what it is that they did wrong?
Yeah, that's the smartest move. Okay. It really is.
Yeah.
Because if it's going downhill, it's not going to straighten out. So just stop and get it back on track and then go forward. No, that's a smart move.
Well, and I think to your point, Steve, when you talked about election challenges and the ability for a homeowner to take it to court, correct me if I'm wrong, but it used to be that a judge would look at it and say, okay, well, looking at the election as a whole, this one infraction wasn't going to change the outcome of the election. So yes, association, slap on the hand, but we're going to let it ride. And the court can't do that anymore, right? I mean, now they just have to invalidate it.
Yes. Well, yeah, actually now the law requires it. So a judge used to be able to sit there and say, yeah, I understand that this thing might have gone out a day late, or there was this thing that happened. But in reality, anybody who's looking at this, that's a reasonable, objective person, says it wouldn't have made a difference. It wouldn't have made it. The election came out how it came out. The judge used to have that discretion. Now a judge doesn't have that discretion. A judge is actually required by law, mandated by law, to invalidate the results of the election. It's kind of like what we see in the collection arena for dealing with assessment collections. Like strict compliance is required, so the standard is raised. So I think it's always good, just make sure every T is crossed and every I is dotted, and if a cross kind of looks like a smudge, then do it over and make sure it's a cross, right?
Because that's going to be a lot less effective, a lot less expensive than paying for legal fees. Even small claims court, they get their consulting fees back, right?
Yeah.
So it's going to be less expensive to just do it over.
One thing we tell our clients is, you could do it this way, and if I wasn't doing my job and I wasn't ethical, I could tell you, do it that way because it's probably going to generate more legal fees for our firm in defending this challenge for you. Or, in terms of what's in the best interest of your association, the corporation, just do it right. Do the election over again. Don't waste money on attorney's fees, and make sure that there's no skeletons in the closet that could bite you.
And the unrest in the community ripples out beyond.
Yeah.
You can't even get that back. So just straighten up and get back on track from the get-go.
Yeah, keep everything.
Because the potential for it to go so far is costly on many levels.
Yeah.
Financial for sure.
Financial for sure, right? But emotional, right? Community discord.
Neighbor against neighbor. It's a black cloud on the community. Yeah.
You're right. I mean, you're asking for a recall election at that point because now the community feels like the board did something.
Yeah. And they're trying to hide something, right?
Yeah.
That's what they always think.
It has that appearance.
Yeah, it definitely.
You can't take that away.
On the topic of recalls, so of the amount of elections that you do, because you do anything that requires a vote of the membership and the secret ballot process under the code, right? So it's large special assessments, grants of exclusive use of common area, right, that don't meet one of the exceptions, board elections, and also board recalls.
Yep.
Of the gamut of all these elections that you do, I'm curious to know how many of them are recalls.
Well, I will tell you they're trending.
Recalls are up, huh?
They are trending, and I don't know if it's just everybody's just a little bit unhappy and a little bit aggravated with life in general, and it doesn't take much. 5% signatures.
Yeah,
it doesn't
petition
take
of
much.
5% of the membership.
So I don't know
right?
if it's free entertainment or what it is, but it just doesn't take much to get going. And here we are. So we're doing a record amount.
This year, yes.
Yeah.
Last year.
And a recall is going to happen, but if you could just wait a few more weeks, the board election's on its way. Nope, won't give it up. That recall is going to go forward.
Really?
So much.
So even though
so much.
Wow, that's surprising. So I know, especially, a lot of associations are on cumulative voting, right, with staggered terms, and then, usually in their documents, in order to recall, one or two board members less than the entire board, we've got this crazy reverse cumulative formula, and I won't go into it
No, it's
because,
crazy.
yes, whoever's listening to this will turn it off right away if I try to explain that process. But at least in our experience, what we see for our clients, they say, oh my gosh, we got a recall petition, what's going to happen? A lot of times they say, well, if this is like the majority of the recalls that we see, it's not going to succeed because you're not going to be able to satisfy that high standard, that reverse cumulative standard. On the recalls that you administer, how many of them do you see are successful? Let's say you had 100 recalls that you do.
You're correct in the formula process because if you've tried to recall less than the entire board, you probably have failed. And if you're hell-bent on having that recall, now you're going to get smarter. Someone educated you somewhere, and now you're going to recall the entire board. You have a much better chance.
Got it, yes.
To be successful.
You're going to recall the entire board, exactly. So even in a situation where someone smarter said, listen, we need to recall the entire board rather than triggering this reverse cumulative formula, how often do you see these recall measures actually succeed?
Maybe 30%.
Yeah, about a third.
Oh, that's more than I thought.
Yeah. Wow, there's a movement going on.
Got it. Okay, here's a question I have.
Okay.
So you send out the ballots, you get the ballots back. Sometimes members would like to say, hey, can you please let us know how many ballots we've received and who's voted already? Because if we know that some people haven't voted already, we want to go knock on their door to make sure that they turn in the ballots. Have you ever had requests like that from board members?
Oh, often. Management, board members, often. But again, in the spirit of the law, we have always taken a very conservative approach to, it's a secret ballot for a reason. If I didn't vote for the governor, I wouldn't want somebody to knock at my door and say, I know you didn't vote, we really need your vote. It's really nobody's business. Maybe you decided you didn't want to vote. So we don't provide any list of who did or did not vote, but we'll tell you how many ballots we have because you have the right to know how close we're getting to quorum.
Got it.
So in terms of the new legislation and all of the ballot materials, with the exception of the secret ballot itself, but all of the balloting materials, the registration list, the membership list, the candidate roster, the outside of the envelopes, all of those are quote-unquote association records now, which are open to inspection.
Yes.
So as inspectors of election, are you allowing, given those inspection timelines, can a homeowner invoke that right to inspect during the course of the election, or are we doing that after
We've always taken the position that it's after the
after?
Yeah.
Not in the middle
How
of.
can it be a secret ballot if you can inspect the ballots before the election?
Well, you're not. You're inspecting the envelopes.
But once again, now you know who did not vote.
Got it.
So I think that's another one of those tricky areas of the legislation, because now it's an association record, and there's a time frame in which those records have to be made available to the member, which could be during the course of the election. So that's why I was curious, as an inspector of election, how do you handle that?
Well, you can look at it this way: during the time of the initiation of the election process and all during it, it's really not the association's records until it's all said and done, and when we turn it over to the association.
I like that.
Yeah, it doesn't become a record until they actually have been, triggered some type of result, or there's some type of formality that's been instituted. Until then, you're just, as inspector of election, you're retaining custody of this information until such time as they become a record, and even for a year after that, right? Even you retain custody for a year after that, right? That coincides with the election challenge time frame.
So if a member wants to come and look at the counted ballots, the return envelopes, the membership list, they're entitled to do that after the election.
After the election.
But not in the middle of.
Because this is a secret ballot.
Correct.
We're here to protect the anonymity.
The privacy of the voter.
There you go. Anonymity of the voter.
Okay, that's what it's going to turn out.
Anonymity of the voter. Well, kind of a related question, I guess. Steve, we have this special election that we're doing. It's to approve the special assessment that we need to repipe our condominium project. This has been a big laboring oar. We finally got the members there. We're going to have a town hall meeting. I know we've already sent out ballots, but for people that come to the town hall meeting, wouldn't it be great right then and there to say, hey, if you haven't turned in your ballot, here's another ballot for you. Please fill this out and turn this. You ever have clients ask you if they could do that?
They have, and back in the day when we were all together, meeting in the clubhouses together, and if they wanted us to attend, we would show up with a ballot and provide that. But we didn't give extra ballots to any others to provide.
Got it. So in a situation where you're physically present as the inspector, it would be okay for you to then hand them the ballot because you're still administering the process, but it's not such that, hey, I'm a manager and I'm going to call up Cathy and Cheryl. Can we have 20 extra ballots? We just want to, litter our community with them when we're doing these types of things to make sure
But with that said, if your town hall meeting is days or sometime before we mail them out, we wouldn't be handing it to you before we'd mailed it. But once it's been mailed to the members, then we could attend a town hall and have extras available.
Got it. But you would still need to be there.
It would be from us to the voter, directly from us to the voter. And now that everything's distanced, now your request to have a ballot, I lost it, I can't remember, is from you to us. Call us, email us.
Got it.
And we'll send it to you the day you ask for it.
Got it. Okay.
So it's directly still from Accurate to the voter, directly.
Got it. Well, that just makes sense, right? Like, it's remarkable, right? All the different things the managers have to do. We just want to make sure that this is successful. How could I help? Sometimes it's important for managers to understand, just stay in your lane here. You've partnered with this third-party inspector of election. We're here to provide this assistance. You don't need to get creative. If you have a challenge, bring it to us, and we'll provide the solution. Don't go off on your own, because that could muck up the whole process, right? If you start handing out ballots doing that, how can you guys certify the vote when you don't know where these ballots came from? These are just extra ballots, right? It would present some challenges.
And it's nicer, I think, for the manager not to have to say no. They can just come to us.
Got it.
And we say no.
And we can say no directly.
Honestly, I think that's great for managers. I think because we've been doing this for so long, and I think just going through rote, I think that managers often feel the need to respond and to participate.
Well, it's hard to distance yourself because you have a relationship with these people.
Yeah, but I think that once they get used to this, and I think once Accurate Voting Services and other inspectors get more involved, I think managers are going to be more willing to just kind of, great, you take care of it. I don't want to deal with it. One less thing on my plate.
Totally.
Yeah, it has been fun for us to see that through these, especially brand new managers who've never used this before. When the election's over, this is what they say. Can you send me next year's contract? This was awesome.
Yeah.
So that's been nice for us to see that our return to renew and service you again has been a really good experience.
Well, congratulations.
And
that's
for
awesome.
the boards and I think everybody.
Well, that's our show for today. Thank you all for listening. We'd like to thank Cathy Tinnelly and Cheryl Wilson for your time and expertise. Make sure you visit our website at tinnellylaw.com if you haven't already, where we break down this episode, and link to our library article, The New State of HOA Election Laws. Then stay tuned for our next episode.
To share or subscribe to the Tinnelly Talks podcast, visit us at tinnellylaw.com. There you can find links to everything discussed in this episode, locate helpful resources, Check out other episodes and submit questions for future topics. And be sure to tune in next month for our next episode. As always, the views and opinions expressed by the podcast, its presenters, and guests do not constitute legal advice. For more information on the topics discussed in today's podcast, please consult with your association's legal counsel. This is Tinnelly Talks, presented by Tinnelly Law Group. Your community, your counsel.